Hey, loungers. I hope everybody is doing as great as I am today. Listen, guys, I'm going to do this as an upload because I think that it would be really great to kind of present it this way. There's a lot of information I would like to go over in regards to both of these cases where we've got Jay-Z and his attorney, Alex Spiro, and other attorneys against Tony Buzbee and Jane Doe. Okay, so there is a lot going on with that case that I haven't seen a lot of content creators kind of going over a lot of these documents, and there's quite a bit of information that seems to be missing. So I wanted to go over those things and just kind of touch base in regards to those things. And I'm also going to talk about the newest information in regards to the TDJAKES case, where DUANE Youngblood has actually filed a response. Okay. Now, this response is not necessarily what the courts were expecting the response to be, but I guess somebody has told this guy that this was actually okay. So we're going to go over these things today. We're going to talk about some case laws. We're going to talk about a few things going on with both of these cases. So buckle up because it's about to be a ride. So the first thing I would like to talk about is regards to Jay-Z and his attorney Alex Spiro, who has been fighting really hard in the courts in regards to this matter. Okay, now they seem to think that somehow they are going to just simply win this case without really having the actual facts and just talking frivolously and just saying anything and throwing anything against the dirt and hoping that somehow it sticks. And I don't know how smart that is, right? I remember saying the other day in regards to this matter how, Alex Spiro had made a huge mistake in claiming that, neither one of these men were friends with one another, considering Jay-Z and Puff Daddy. Okay. And, I told him, like I said, I thought that that was a clear mistake on his behalf. Okay. Just simply because, now he would have to walk back these things. It makes him and his client look like, they're just being dishonest. Okay. And it makes it hard to believe anything else that they're saying. So I'm going to share my screen and what has been going on with this case on Pacer, because there's quite a bit of information that I think is being overlooked by people who simply want to just, kind of throw this Jane Doe under the bus, and find a way for Jay-Z to be correct in these matters. Okay. And I think that's a grave mistake. I definitely think that this is something that should be checked at, should be looked at, because I think this is a really big deal. Okay. Now, what I'm doing now is I'm going to share my screen and show you guys my Pacer, okay, where this is at. And let's take a look at some of the things that have happened in this case. So as you guys can see, this is the case with Doe versus Combs. Okay, this is the case number here, and the Honorable Annalisa Torres is presiding over the case. The last date of filing was yesterday, and we're going to go over that actual letter that Tony Buzbee put out to the court. I do think that that is going to be what will make Jay-Z actually face the music with this matter, okay? Because there's been quite a bit of things that have been filed. Particularly, it really started to heat up on the 8th, on December the 8th, with the amended complaint that was filed by Tony Buzbee, which actually named Sean Carter, aka Jay Z, in this lawsuit. Okay, this is where things really started to heat up. He requested the civil summons. This was all sent out to Jay Z. Jay Z's address and everything is on this paperwork, so I really don't want to show that stuff because I think a lot of people know where he lives, but I don't want to be one that's doxing this guy, okay? Because this information is definitely public information, okay? But either way, there's quite a bit of information in here for between both of the attorneys, but particularly one of the attorneys which is Jay Z's attorney, has been really pushing this issue of certain rules that he claims are being violated by Tony Buzbee. Okay, so there's a couple of letters that he filed, and there's one in particular that I would like to read with you guys. So let me go ahead and pull this one up. This was dated December. This was filed on December the 10th. Okay, and I think it's important to kind of read this letter so that we see kind of what's going on here and exactly how this has been happening. So bear with me while I pull this letter for us because this is nuts, y'all. This is crazy. Coming from an attorney, I really think that I don't know how smart this was for this guy, for this Alex Spiro to post this. Okay, so let me go ahead and share this tab with you guys. And on here is a letter that was sent from Alex Spiro's attorney's office. Okay, and this is dated on December the 10th, and it was sent via U.S. mail to the chambers for the judge, as well as just to the court. It is regards to Jane Doe versus Sean Carter, okay, and this is the case number for that. Dear Honorable Judge Torres, on December 8th, 2024, plaintiff filed an amended complaint naming my client, Sean Carter, as the defendant in this lawsuit. On December 9th, 2024, we filed a motion seeking to have the court decline to permit the plaintiff in this case to proceed anonymously. As noted in that motion, plaintiff's attorney Anthony Buzbee has engaged in a campaign to leverage unfounded and heinous allegations against celebrities to secure large settlements. He seeks neither justice nor peace for his victims. He seeks only to benefit himself. That is a pretty big, allegation to make, right? Without having substantial evidence of such. Now, we're going to get into what he claims to be evidence of this in just a moment, okay? But again, like I said, I know that attorneys like to fight hard, on behalf of their client. Obviously, the more money they're paid, the harder that they'll fight. But also I think as an attorney you have to be smart in doing these things, especially if you're going up against another seasoned attorney in these matters. This is not about what the public believes, right? But you got to remember that you're speaking to an actual judge, and that this judge has the ultimate say in what will happen in these matters. Okay, so that is who you need to be impressing, and not trying to impress the public, which it seems like this is what's kind of happening with this, with these huge allegations against this attorney without really providing any actual evidence of this. Okay, now I'm going to get into again what he is claiming is quote unquote some evidence of these things. Okay, but then we're also going to get into what Buzbee has to say about these things as well. Okay, now he says, on the afternoon of December 9th, 2024, after we had submitted the motion and accompanying exhibits, our office received an outreach via phone call and email from an individual who provided her name to us, though wishes to remain anonymous. Now, before we go any further with this, I really wanted to stop at that, okay? Because the whole entire argument that Jay Z's attorneys are pulling out to begin with when this whole thing came out is that they wanted the plaintiff's name to, or they wanted the name of the accuser to be put out to the public. Okay, they felt like this person being anonymous was violating certain rules, and one of them was Rule 12. Okay, which is where a party must serve an answer to a counterclaim or cross-claim within 21 days after being served with the pleading that states the counterclaim or cross-claim. Okay, they were trying to use Rule 12 in this defense in claiming that this person who is anonymous kind of violates the rule of countering a claim or being able to cross-examine such a person, when in actuality that's not always the case, and people can in fact remain anonymous while filing while filing cases for various reasons, to protect themselves from harm and so forth and so on, to protect themselves from the media, these kinds of things, especially in very high profile cases like this with very powerful people like Sean Combs and like Sean Carter. Okay, so it's obviously quite understandable that a person who is going up against them would want to keep their name anonymous. Okay, as and also to protect future people who may want to come forward as well. Okay, so Rule 12 does not necessarily apply to this matter, especially when this person has counsel that is coming forward, is saying who they are, and they are representing this person. Okay, so I'm not sure how much Rule 12 will actually apply to this, but we'll see what the judge has to say in regards to that. But, ultimately, their whole problem was they had an issue with this person remaining anonymous, yet they're willing to, present to the court some information on someone who wants to remain anonymous, right? Like, I just find this absolutely absurd and crazy. Okay. But either way, let's go ahead and keep going. Mary Henderson spoke to this woman who informed Miss Henderson that she had previously reached out to the Buzbee law firm with respect to allegations of trafficking and abuse unrelated to Mr. Combs or Mr. Carter. The Buzbee firm representatives with whom she spoke asked the woman, let me make this a little bit bigger for you guys. The Buzbee firm um, the Buzbee firm representatives with whom she spoke asked the woman when she met Diddy, even though her even though her account did not relate to Mr. Combs at all. Members of the Buzbee firm encouraged this woman to pursue her claims anonymously, even though she did not have any interest in doing so. When the woman raised wanting to talk to law enforcement, she was informed that it was not encouraged. After several outreaches, the woman again spoke with members of the Buzbee firm when she felt were when she with whom she felt were pressing her to make allegations of being drugged, held down, and physically assaulted, allegations that were not true. When the woman declined to adopt the version of events proposed by members of the Buzbee firm, she was summarily dropped as a client. Though the woman provided her identity to Miss Henderson, she wishes to remain unnamed at this time for the fear of retaliation by the Buzbee firm. The information provided by this woman is in the Declaration of Mary Henderson, attached hereunto as Exhibit A. This information, which came to Quinn Emanuel unsolicited, is further evidence in support of Mr. Carter's right to thoroughly investigate, test, and respond to the spurious allegations that have been leveled against him. We respectfully request that the court consider this additional information, which was received by Quinn Emanuel only after filing of yesterday's motion was complete, in connection with the motion to deny the plaintiff's request to proceed anonymously. Respectfully submitted, Alex Spiro. And child, listen, I think this was a huge, huge mistake on behalf of these seasoned attorneys that Alex Spiro and his team should be. Okay, Number one, this is a really huge, mountain to climb, trying to prove such a thing. Okay. Why would it be that suddenly, out of the blue, right? Out of all this time that this has been going on, all of a sudden now, right? This particular person wants to come forward and speak on behalf of what has terribly happened to her, you know, from the Buzbee law firm, in regards to this matter. How come this is only coming up now? How come Sean Combs' attorneys never got this phone call, right? They never received this information when they are the ones that are fighting for his life right now. He is the one that's literally locked up. They will not, they have denied every bail package he has given, so forth and so on. And they never got this phone call in regards to the Buzbee law firm. Buzbee has been, actively and seriously coming after Sean Diddy Combs. Okay, so this whole thing with Sean Carter just recently started. Okay, so I'm not sure why this person all of a sudden would be willing to come forward only in the case of Sean Carter, but not in the case of Sean Combs when they were the ones that were claiming, and what they're saying now is that Buzbee firm was trying to force this woman to speak on Sean Combs, not Sean Carter. They even made that very clear right here, where they says, you know, that this is unrelated to Mr. Combs or Mr. Carter. But then they went on and proceeded to say that this woman was saying that she was being, coerced into and forced into, speaking against Diddy. Well, how come Diddy's attorneys never brought this up? How come they've never heard about this? Only Sean Carter's, attorneys have heard about this after they went on this crazy, campaign with, all these news stations and newscasters trying to claim that, Jay-Z and Combs aren't even friends, which we've definitely proven that to be a lie, right? That they don't barely know each other. They only know each other as colleagues per se, and this is all fake and false, and he has nothing to do with anything ever going on with Combs and so forth and so on. I find it really strange that they would go to this length, to go this far. I mean, it's pretty obvious that this is a made up individual, right? Now, I don't know. I could be wrong about that, right? But that's my opinion that this is obviously a made up individual of a woman who is in Exhibit A talking to Maury Henderson and telling her, that this is what's going on. So we've got under penalty of perjury, Maury Henderson, who works for this law firm, swears under penalty of perjury as follows. I am an associate with the law firm of Quinn Emanuel Uhart and Sullivan LLP, attorneys for defendant Sean Carter, and I submit this declaration in support of Mr. Carter's motion to deny plaintiff's motion to proceed anonymously. On December 9th, I spoke by telephone with a female adult resident of the state of Texas whose name is known to me. Another adult whose full name is known to me was a witness to the conversation. The information contained in this declaration is an accurate summary of the information provided to me by this woman on December 9th, namely that A, in early October 24, this woman saw coverage of attorney Anthony Buzbee's press conference regarding allegations of trafficking and abuse by Sean Combs and submitted a brief outline of trafficking exploitation events via a Buzbee law firm website online submission form. The woman spoke with three members of Mr. Buzbee's firm and provided details regarding her experience as a victim of trafficking by celebrities entirely unrelated to Mr. Combs or Mr. Carter. And she told them they would take her on her representation. After detailing her experiences to an attorney at Mr. Buzbee's firm, he pressed for connection to Mr. Combs, asking, "At what point did you meet Diddy?" Even though she made clear that her case was unrelated to Combs. D. Mr. Buzbee's firm pressed for the woman to pursue a civil case as an anonymous Doe plaintiff, even though she never raised proceedings anonymously as a possibility and questioned doing so after it was heavily suggested to remain doing so, even though she was not interested in remaining anonymous at the time. When the woman brought up wanting to go to law enforcement with her allegations, members of the Buzbee firm informed her that going to law enforcement was quote unquote not encouraged. Okay, which is just that's just so vague, right? Why was it not encouraged? Like after not hearing from Mr. Busby's firm for weeks, during which this woman tried to contact the firm multiple times, she spoke again with a member of the firm who pressed her to confirm false details regarding her experience as a victim, including that she was drugged, held down, pushed, and physically assaulted. She felt directed and coached by Mr. Busby's firm to say that someone held her down and put drugs in her mouth when that was not her experience. She felt forced to lie. When the woman made clear that she was unwilling to adapt to the narrative Mr. Busby's firm laid out and wanted only to speak her truth, she was dropped as a client and told that Mr. Busby's firm was unwilling to represent her at any longer. She felt as though once she had expressed that she was not a coachable victim, she was dismissed. This woman shared this information because she felt the conduct by Mr. Busby's firm, specifically to encourage lies, discredits those who are legitimate victims. This woman expressed that she fears retaliation from Mr. Busby's firm if she shares her true identity or signs her name to a declaration in this case at this time. And then she says, I declare under the penalty of perjury that the foregoing statements are true and correct, executed in Los Angeles, California on this 10th day of December 2024. Now, here's some holes in this story. Okay. Number one, she says that the woman expressed, and here in she says, this woman expressed that she fears retaliation from Mr. Busby's firm if she shares her true identity or signs her name to a declaration in this case at this time. Why would that be the case if they obviously would already know her true identity, right? If they were talking with her so much to the point that they heard her case, they listened to her case, and then they gave her suggestions on what to say. It is clear and evident if this is true, like what they're saying about how many times they've had conversations, how many times they've been in touch with this woman. See, I think you got to think with critical thinking here. Okay, if they've been in touch with this woman as many times as Jay-Z's attorneys are claiming, right? And they've spoken with her and spoken with her for many weeks, right? Over these things, and again saying after not hearing from Mr. Busby's firm for weeks, during which time this woman tried to contact the firm multiple times, she spoke again with a member of the firm who pressed her to confirm false details, right? So obviously, they knew who she was. Obviously, they already knew what her identity would have been. So, does it make sense to then turn around and say, now this woman fears retaliation from Mr. Busby's firm, if she shares her true identity? But they would already know who that would be if this is really a true story, right? If they were actually telling her this and she told them, no, I'm not going to do this, unless they have hundreds of people that this is happening to, then I would expect hundreds of people to start coming forward and saying something in regards to this, someone else to back up this story, right? But again, the anonymity doesn't make sense in this matter if this person has been obviously, according to their own words, working with Busby's firm all of this time. Okay, so I think that was a serious and huge mistake on behalf of Jay-Z's attorneys once again. Okay, again, a lot of these attorneys just like to make money. They can care less whether you get off or not, right? They're going to act like they care, but they really can care less if you get what you want. um, I think it was very emotional of these attorneys to jump the gun and start throwing allegations of such out at such a seasoned attorney as Tony Buzbee. And now let's get into what his response was, because he actually had a very interesting response to this. So let's go ahead and take a look at the rest of what ends up happening here. Okay. So we got the complaint. We got where they put in these proposed orders. They're requesting summonses, motions for relief. All these things are happening, right? And then we've got here where this is a notice where the attorney is regarding deficient request for issue of summons. We've got the notice to court regarding the proposed order. All of these were granted, okay? And then there was a notice to appear, motion for miscellaneous relief, and so forth. All of these things happened. Okay. Then there was a motion for expedition of this matter. Okay. That's where we got the letter, request for issue of summons. And let's get this letter here, because this letter here is an actual letter from Buzbee, and we're going to read this letter in response to the letter that that the attorneys for JAYZ wrote. Okay, because this is nuts. So let's go ahead and share this screen here. Let me make sure I'm sharing with you guys. Okay. Okay. Hold on, let me make sure I got it right. Okay, so we got again from the Buzbee law firm. Okay, we've got the case law here. We've got the letter briefs filed for Jane Doe versus Sean Carter. Dear Judge Torres, I write on behalf of my client Jane Doe, as well as on behalf of myself and my firm, in response to several recent improper communications directed to the court by counsel for defendant Sean Carter in the above captioned action. On December 8th, 2024, my client filed an amended complaint naming Mr. Carter as an additional defendant in this matter. In conjunction with this filing, my firm filed a renewed motion for the plaintiff to proceed anonymously. Rather, rather than merely oppose that motion as would be expected and proper defendant card and I'm sorry, let me read this again. Let's read this again. In conjunction with the filing, my firm filed a renewed motion for the plaintiff to proceed anonymously. Rather than merely oppose that motion, as would be expected and proper, defendant Carter filed the very next day his own motion to deny anonymity and or dismiss Rule 12b1. Okay, which again, Rule 12b1 is a party must serve an answer to a counterclaim or cross-claim within 21 days after being served with the pleading that states the counterclaim or cross-claim. Okay. It appears that defendant Carter made that separate filing, which we believe to be procedurally improper and substantially deficient, to serve as the pretext for defense counsel to submit two letter briefs to the court on December 9th and 10th. These letter briefs are frankly nothing short of defamation, hiding behind the thinnest veneer of litigation privilege. Okay, which again, like I just said, after reading those letters from Sean Carter, right? After reading those letters from his attorney, or reading that letter from his attorney, it definitely sounds like he has a very serious uphill battle to prove any of these things that he is claiming about this very seasoned attorney. Okay. Like I said, I wouldn't go into a case with defamation knowing that I can't really back up these claims, or that I'm using frivolous claims to back these things up. No, I don't know what type time this attorney is on, right? I really think that people are not paying attention to how Alex Spiro is moving in this matter. Okay, and I think that is very serious for Sean Carter. Now, it says, except for the one sentence requesting an expedited hearing, the letter briefs have absolutely nothing to do with the only pending issue before the court, namely whether my client should be allowed to continue to proceed anonymously. The letter's otherwise irrelevant contentions that the amended complaint's allegations are inflammatory and frivolous as against counsel's plea that Mr. Carter is entirely innocent, a merely press release dressed as filings, as legal filings. Okay. And again, like I was saying that, this is more for, it looks like the court of public opinion that, that Spiro is trying to turn, right? As if he's trying to turn the future jury in this matter, as if he's trying to turn, the thoughts of the people in this matter, as opposed to, protecting, what the courts would look at in this matter. and proper and properly filing this case and properly having this case looked at and and judged upon. I think that that is a serious issue when it comes to Jay-Z's attorneys here. Now, then he says here, counsel's December 10th letter goes much further and entirely too far by accusing my firm and I of outright unethical behavior that never happened and which I would never countenance. To be clear, my firm and I categorically deny all of the baseless allegations levied by Mr. Carter and his counsel in these letters. We will respond in due course and due time through memoranda of law and other appropriate means to the legal issues at hand, as well as the accusations raised by Mr. Carter and his counsel. We will also address verifiable improprieties committed by defense counsel, outright legal conduct for which we have actual evidence rather than vague hearsay declarations. For the moment, we simply want to timely inform the court that such responses will be forthcoming. Respectfully, Anthony G. Buzbee. And he filed that on December 10th, the same day that that lawsuit or that letter came from Sean Carter's camp. Okay. So again, I don't think they're thinking this through. I don't think that though Alex Spiro and Sean Carter are thinking this through. I don't think that they are looking at the serious parameters surrounding this matter. That you cannot, this is not MTV, this is not BET, where you can just throw out whatever you want about somebody and everybody just, is entertained and, everybody gets an award at the end of the year and that's it. That's not what this is. This is real life. Okay. Somebody at 13-year-old at the time is allegedly accusing this man of assault along with Sean Carter, along with Sean Combs, and he needs to face the music. I think that, his attorney has made it as if, Jay-Z is some kind of prince or some kind of king, and, he gets treated with special privileges that other people don't get. I do think that, unfortunately, he has experienced that in some ways. And so now in this particular thing, he's expecting his attorneys to fight for him in these ways, and he pays them enough to put on such a show, and that's unfortunate for him because this is real life. But again, we don't know what this judge is going to say in regards to this. But let's get on to the letter that was filed as of yesterday from Buzbee's office because there was more that came out in regards to this. So I believe that I read this one already. This one is where Exhibit A, where the lady was saying that she had spoken with this woman. So let's go ahead and look at the things that have been going on with the case prior to that. Okay, so bear with me just a moment while we look at that. Okay, now since that letter that Buzbee filed, okay, on the 10th, there was a summons issued, a motion for conference was filed, notice to court regarding the proposed order, and this is basically um, where Sean Carter's team was proposing this order to show cause without emergency relief. They wanted this to be quick and fast, and kind of going against some of these rules here that we're going to talk about in just a second. Okay, and I got definitely wanted to look into some of these court cases and some of these things that have been happening out here because this seems to be a very, very serious issue that we're heading into. We are definitely heading into some very hot, boiling hot waters when it comes to this case. Okay. So, they had basically filed this motion to show cause for without any emergency relief, and they were basically using now Rule 11, okay, in this matter. Okay, and let me go ahead and give you guys what Rule 11 is in this. So hold on one second. They wanted to use Rule 11 with the preservation order because this is asking for that. And a preservation order is basically a legal directive that protects important cultural or environmental resources, and in the case of law, to protect any evidence from being destroyed. Okay, so that's kind of what that's about. But Rule 11 is it's basically every pleading, written motion, or other paper must be signed by at least one attorney of record in the attorney's name in order to prevent frivolous lawsuits. Okay, so what they want to do is they're basically trying to make it appear that this is a frivolous lawsuit that has been filed on behalf of Attorney Buzbee for Jane Doe. Okay, and they are saying that this case should be thrown out now because this is frivolous, this shouldn't be happening, and they want to show cause. They want Busby's firm to show cause without any emergency relief to this order in regards to Rule 11. Okay, so they're basically saying that this is frivolous, this is wrong, they should not be filing this, and we want him to show cause for this not being a frivolous lawsuit. Okay, that's basically what they're saying there. So after that was filed on the 18th. Okay, and then the 18th, there was a memorandum for law to support in support of this. Okay, so they use a particular case law in support of this, and the declaration of that support. And here finally is the letter that Buzbee actually sent, okay, to them on the 20th. So bear with me just a moment while I pull that up. Okay, so let's go ahead and share my screen. And this again was filed on December 20th with the Honorable Annalisa Torres in the United States District Court, Southern District of New York. Okay. Now, before we get into this, there has been some confusion of whether or not Tony Buzbee is actually allowed to file within this court, and whether he is able to practice law in this court. We'll get into that in just a moment because that actually is something that I found out is happens quite commonly, and I'm going to give you the rule, the law rule on that as well. So this was filed yesterday, okay? And it says, Dear Judge Torres, this is in regards to the plaintiff's response to Shawn Carter's request for expedited Rule 11 motion, okay? Which again is that every pleading, written motion, and other paper must be signed by at least one attorney of the record of the attorney's name or by the party personally. And that would be to prevent frivolous lawsuits, okay? Because they're claiming that this lawsuit is frivolous against Shawn Carter. Okay. Now, dear Judge Torres, by letter motion filed December 13, 2024, defendant Shawn Carter notified the court of his intention to file a motion to strike and motion for sanctions immediately under Rules 11C, 2, and 12F. As with defendant Carter's prior letters filed in this case, it is histrionic in tone, but substantially groundless. Defendant Carter threatens plaintiff with Rule 11 motion based on questions raised by one single television interview concerning events occurring 24 years ago when plaintiff was 13 years old. Defendant Carter also asked the court to alter the federal rules of civil procedure in this favor by abrogating the mandatory 21-day Rule 11 safe harbor period without any legal support or factual justification whatsoever. The former is frivolous and the latter is impermissible. Now, let's go over that just for a second. There was a letter that was filed on December 13th by Alex Spiro, okay, and his team, which claimed in this Rule 11 matter that this was a frivolous action and that they wanted to immediately seek sanctions on the Buzbee law firm for this frivolous case, okay, which again he could face sanctions if it turned out that he was you know prepping his people to talk or telling them what to say and stuff like this, which would be serious allegations, which would also be, some serious sanctions would come against him if these are the case. Okay. If he was like, you know, telling them what to say and these kinds of things in order to collect money. This would be a serious deal if that was the case. And this is what they're accusing Tony Buzbee of doing. Okay. So again, with that Rule 11 situation, they're trying to claim that this is based off of this woman going on NBC of all places, all right? And it's claiming, I want to talk about that NBC case for just a second too. But going on NBC and giving them what they say is partial stories and so forth and so on. Here's the problem with that. We never saw that full interview. Number one, they never released the entire interview. They just told us parts of the story. And then when they got to other parts of the story, NBC would cut in and say, well, this is inconsistent with what we have. But they never told us what the inconsistencies were, right? They just kept saying there were inconsistencies without giving us the actual inconsistencies. That's number one. Number two, the father that they claimed that they interviewed, right? How come we never heard from him directly? It's only them telling us that they heard from the father. This could have been anybody. This could have been any paid actor or anyone, or it could have never been an interview at all. That's just could have been something that they put in there. Money talks, and enough money from, a certain individual very well may make, a news company or anyone lie on behalf of people. This is not far fetched. This happens all the time. So, I wouldn't be surprised if, this whole story with NBC is just completely bogus and nonsense to begin with. Okay. Now, one thing I will note is that Buzbee is not denying that Jane Doe is the actual person that was interviewed on NBC. Now, he could have very well said, my client never was on NBC, right? That could have very well been said, but he hasn't said that so far. Okay. The only thing he is saying is, listen, this happened 24 years ago when the plaintiff was 13 years old. And he gets into a particular case law in regards to this that we're going to get into as well, okay, in just a minute. Now, he says Defendant Carter also asked this court to alter the federal rules of civil procedure in his favor by abrogating the mandatory 21-day rule safe harbor period, okay, which is given in this matter where, where they have the time to file and look at the proceedings. They have the time to look at to go over the proceedings with their client. They have the time to file a response to this, and there's a safe harbor period where each case has that. Okay, JAYZ's team is trying to ask this expedite and to request this to not even happen. That they need her name now. They want her information right now, right? And it's possible that the judge might sign off on that. I'm not going to hold you, right? It's possible that they might. I'm not saying that they will, but it's quite possible that they might, just based off of, if there is evidence that that there's some kind of coercion here, or there's something, that's going on, and there's true evidence presented to the court of such a thing, the judge may actually allow certain things to come forward expeditiously. Okay. So I don't know in this particular case, right? I don't know what's going to happen with that. I wouldn't get my hopes up in regards to that and thinking that, JAYZ is automatically going to lose that one. But it's a strong possibility that he would, just based off of some of the case laws that Buzbee uses in this case. And this guy is a seasoned attorney, I have to say. Now let's go ahead and keep going here. So he then goes on to say that Defendant Carter's threat of a Rule 11 motion is frivolous because it characterizes run-of-the-mill disputes of fact as proof that plaintiff's complaint is baseless. None of the factual issues Carter identifies are sufficient even to grant summary judgment in Carter's favor. Okay, so let's go ahead and make this a little bit bigger, much less support Rule 11 sanctions. The fact that the defendant or a potential witness does not agree with or recollect the facts alleged in the complaint does not and cannot give rise to a motion for sanctions for filing a baseless complaint. Defendant Carter's threat of an immediate sanctions motion on this first whisper of factual uncertainty is just one more instance of bullying intended to have a chilling effect on plaintiff's counsel, and any potential plaintiffs watching these proceedings. Okay, I think that is a very strong statement to make. And I think it's got some truth in it, right? Now let's listen to what he said. I just want to break down a little bit of what he said here. He said that the Carter's threat of Rule 11, right, which we all know, which is the signing of the proceedings and given the 21 days to respond and so forth, right? um, of that motion is frivolous because it simply characterizes a run of the mill dispute of the facts as proof that the plaintiff's complaint is baseless, meaning that when they spoke to quote unquote NBC and then this quote unquote father falls out of the sky and claims this and claims that, he didn't even get into all of the actuals and factuals of that, right? I think he's going to allow and I think it's smart on Buzbee to just kind of allow that to just lay to the side while he looks at the actual facts in the matter, right? The facts of the matter is this. At the end of the day, this quote unquote potential witness not agreeing with or recollecting picking up a child and all these other things, are really, kind of doesn't really matter in regards to this matter, right? And it doesn't give reason for motion for this to be a baseless complaint just based off of what NBC has said, right? Because only NBC has told us this. So far, I have not seen anybody's father who has come forward and said anything, right? I've seen NBC tell us that somebody's father came forth and told them some things, right? But that's all we've seen. We've seen NBC break down alleged interview with someone where it's just kind of broken into pieces where NBC put in their report of what was inconsistent as opposed to us hearing directly from them of what may or may not be inconsistent. Okay. And then they added that this person has autism on top of that. Okay. So let's go ahead and finish with this here because as it says here, this doesn't give rise for them to file this as a baseless complaint as defendant Carter of an immediate, sanctions on this, which, him asking for these immediate motions on here is almost feels as if they're trying to intimidate the plaintiff, right? As if they're trying to bully the plaintiff and the plaintiff's counsel, and particularly send a strong message to anyone else that may want to come forward. Oh, we're going to get your name. We're going to find out who you are, that kind of thing, right? So I thought that was a very strong claim to make. But unfortunately, Jay-Z and his team have been very, very, um, um, I'm trying to look for the right word. They've been very careless in not covering up such behavior lately. Okay. And we'll get into that in just a moment. It says a Rule 11 motion is frivolous on the additional ground that expecting a victim of S assault over 2 decades ago, and this is where it gets really hot for them, over 2 decades ago, when the victim was a minor, and as her interview revealed, also autistic, to have perfect recollection and recall all of the facts is absolutely outrageous. And I absolutely agree. And there is a case law to prove it. Defendant Carter twists plaintiff's words when he accuses her, for instance, of guessing at the timing of events alleged in the complaint, such as the length of car rides. But New York courts have expressly acknowledged the plaintiffs in this type of case cannot be expected to have exacting recall and command of all relevant facts. Now I'm gonna go ahead and highlight this right here because this right here is where Sean Carter may have to face the music. Okay. But New York courts have expressly acknowledged that plaintiffs in this type of case cannot be expected to have exacting recall and command of all relevant facts. See Pasula versus Roman Catholic Archdiocese of New York, 201 AD 3D, and then it gives the numbers. So I looked up that case law, okay, and I wanted to kind of see what it was about. And this is a plaintiff who alleges that he was S assaulted from 1965 to 1967 when he was 12 to 14 years old by defendant Edward Gaynor. Okay. And this, in this particular matter, stated that, and I'm going to quote, we recognize that the matters of S abuse involving minors, as recounted by survivors years after the fact, dates and times are sometimes approximate and incapable of, of calendrical and exactitude, and approving allegations spanning a 4-year window of time in which the abuse could have occurred. Okay. This right here, you guys, is what I believe. And shout out to Buzbee. I think this was very, very smart on his behalf. I think that this is what kind of, was the fire to the brimstone, okay, in this particular situation, where he used a very, very strong case, that, of course, definitely pulls on the heartstrings of people, definitely will pull on the heartstrings of the judge in this situation, possibly, that cannot be denied. That has been used many, many times. That has been talked about many, many times. And many, many people have won their cases against the archdiocese based off of this particular case. Okay. And based off of this particular case law and this particular kind of case law. Okay. I think that this here is not good for Jay-Z at all. Okay. Now I'm going to read this again. We recognize that in matters of S abuse involving minors, as recounted by survivors years after the fact, dates and times are sometimes approximate and incapable of calendrical exactitude, and approving allegations spanning a 4-year window of time in which the abuse could have occurred. So, if she's saying that this happened in 2000, it's possible it could have happened in 2002. It's possible it could have happened in 2003. It's possible it could have happened in 2004, according to this case law. Okay. Because she was 13 years old at the time. And so, with her being 13 years old, having autism, right, as well as claiming that she is the victim of two individuals with a third party on the side, this case law protects her in this matter. Okay. And I think this is kind of, like I said, the bombshell in this situation. So shout out to Buzbee for bringing that up. Um, and then he goes on to say there is no basis for a Rule 11 motion here. And if filed, such a motion itself would be subject to Rule 11 motion in response. And I have to agree with that, right? If it turns out that he tries to file this motion and wins such motion, now he can go back and file a motion Rule 11 against this with with the frivolousness of this, where he's claiming all these things about Buzbee and about his firm and about the client and all these things that he's claiming about this, you know, and he'd now have to prove that these things are true. So again, I really think that Buzbee fought very hard with this one, and I think he did an excellent job of this. And then he goes on to say, of course, we cannot prevent defendant Carter from wasting the resources of this court and all parties in pursuing one, right? Which is true. He can't tell him not to if he wants to go ahead and go after this way. But however, defendant Carter's request that the court shorten the filing deadline for his threatened Rule 11 motion from 21 days to 1 day is entirely improper. Carter fails to cite any precedent whatsoever to support this astonishing request, because there is none. Carter also fails to cite any reason why the federal rules of civil procedure should be abrogated in his favor in this particular case. Again, there is none. And this kind of falls into what I was saying about how, Carter has been kind of used to people just doing things for him, people just offering favors to him, right? Because he's who he is, because he rubs shoulders with who he does, and so forth and so on. And it's kind of like, it's like his slip is showing with this. It's like Alex Spiro is allowing his slip to show with this, which I find crazy. Okay. So again, let's go ahead and keep going. The 21-day safe harbor rule under Rule 11 exists to provide parties and counsel time to access the objections being made and to withdraw or modify a pleading or other paper if necessary. FRCP, which is some case law he gives, And then he says the safe harbor period has been recognized by the second court as a strict procedural requirement. And then he gives some more case law to back these findings. Okay, safe harbor requires motion to be served 21 days prior to their filing. It cannot be shortened here because Mr. Carter and his counsel, quote unquote, request as much, whether in an attempt to play gotcha or exert additional pressure on plaintiff or for any other reason. And I completely agree with that. Again, we're not here to collect favors, right? He has to face the music like anybody else would have to face the music. I'm not sure why he thinks he doesn't. From the outset, Defendant Carter and his counsel have shrilly maintained an entitlement to different rules and faster procedures, from expedited briefing on the issue of anonymity and a summary dismissal of plaintiff's complaint to now a wholesale elimination of the 21-day safe harbor rule under Rule 11. In each instance, the goal has been to blur the facts and to rush a decision. But there is aggressive advocacy, and there is also bad faith. Mr. Carter's latest tactics, much like his open threat to refer plaintiffs' attorneys for disciplinary action across that line. Moreover, outside of the courtroom, Mr. Carter has employed tactics of intimidation and harassment, even more extreme, torturous, and quite possibly illegal. My firm recently filed a lawsuit in Harris County, Texas, that details how Mr. Carter's company, Rock Nation, and his counsel have bribed my clients to file lawsuits against my firm. Now, this, guys, is serious. Okay, we're going to get into this in just a second. Threatened former clients, impersonated state officials, and engaged in other behavior far beyond the pale of acceptable conduct. Their tactics won't work, and they will be addressed in more detail in connection with the parties' briefing on plaintiff's anonymity. Now, I would like to get into this for a second. Now, he says that he's claiming this is a huge claim to make, right? A huge claim to make. But he has actual evidence of it. He actually presented actual proof to the Harris County, Texas courts in regards to this. And you guys can check this out on Pacer. It is there. It is Buzbee's firm against Rock Nation, and it is huge. It is a big deal. Okay, what he is alleging is that Mr. Carter has employed some people who have claimed to be from the state, who have claimed to um, you know, uh, do all kinds of stuff, and that they are offering money to people, that they're offering money to YouTubers, that they're doing all kinds of stuff to go against the Buzbee law firm. Okay. I mean, he is just tossing money out here like it's nothing. And I'm wondering again if this is another thing that Jay-Z has just been kind of used to doing, right? Been, used to being able to just throw a couple $1 million at a situation to make a situation go away, right? What's $1 million to a billionaire? You know what I mean? Like, I mean, yeah, right? Easily he can throw away a couple $500,000 or $1 million for a cause, to help it go away. And that to him would seem like more than enough money to save, to move some people's lives and change some people's lives, and give them a few $1,000s, couple $100,000 somewhere, and that would change their lives enough where they would be willing to lie, on his behalf, or be willing to, to come forward on his behalf. Now, I don't have any evidence of this, but allegedly Tony Buzbee claims he does. Okay. And he has presented this to Harris County in Texas. Okay. And we're going to see where that goes. Okay. I'm definitely going to be following that case and see what happens with that. But again, he is claiming that they are bribing his clients, whether they're former clients or current clients. They are getting a hold of these people. They're using intimidation tactics and so forth. And that is a serious, serious allegation with some serious, serious issues to follow up if this turns out to be the case, because this would be called witness tampering. Okay. And witness tampering can result in severe legal consequences, including substantial fines and or prison sentences, depending on the severity of the actions taken, which again can range from a few years in prison for harassment to life in prison for witnesses being killed or, to obstruct justice. And in most cases, any threats of physical force can also lead to a maximum sentence of 20 years in prison. Okay. Would it be worth it for Jay-Z on, for this? I'm not sure if it would be worth, putting his family, in harm's way, putting, his life on the line for this, all of this. If it turns out it's not true, it's just simply not true. Why would you go through all these loopholes, right, to prove that it's not true when you can just simply follow the law with this matter? You know what I mean? If you got to go through all of this kind of stuff, it definitely makes you question whether this is true. And like I said, there are people that are coming forward openly with Tony Buzbee's firm claiming that these things have happened. Okay. There are actual YouTubers that are talking about this as well, where they've been approached by um, Sean Carter's team. They've been approached by Diddy's team and so forth to change their story and, to get paid for it. There was this one guy who the quote unquote investigators, the state officials or whatever, they were at his house and he had them on camera like, what are you doing here? I can't believe y'all showed up to my house. This is crazy. But he had been talking about the Diddy lawsuit and what was going on. So it is not far-fetched for this to be a true story. Okay. And that Buzbee is now putting this out here as a fact. Okay. Like Mr. Combs, Mr. Carter is rich, famous, and powerful. Mr. Carter will exert all the pressure he can to intimidate and harass plaintiff, me, or anyone else. The chilling effect of those efforts is substantial, as is the potential chilling effect of Rule 11 motion being brought in these circumstances, right? Claiming this is frivolous to begin with. But ultimately, in our court system, the rules are the same for Mr. Carter and for the plaintiff here, and the Rule 11 safe harbor cannot be abrogated on his whim. Finally, defendant Carter raises the status of my admission in the Southern District Court of New York. As with his previous letters to the court, his December 13th letter includes a substantial amount of defamatory suggestions about me, including that I am somehow attempting to circumvent the authority of this court to enforce Rule 11 against me. That is nonsense. I am a member of the State Bar of New York and am admitted to the Eastern District of New York. I intend to apply for reciprocal admission to the Southern District. The fact that I have signed pleadings and letters filed in this court does not reflect any attempt by me to evade responsibility for anything. To the contrary, I have signed those pleadings and papers because I am lead counsel in this and other similar cases pending in this district. And that is actually what a lot of attorneys do, which is what we're going to talk about with the TDJAKES case in just a moment, because his attorneys have actually filed for what's called pro hac vice, okay, which is something that many attorneys use. And in the legal field in the United States, pro hac vice is a practice in common law jurisdictions whereby a lawyer who has not been admitted to practice in a certain jurisdiction is allowed to participate in a particular case in that jurisdiction. Okay, so it's basically asking to be here for only on this occasion. That's what pro hac vice means, and it's in its raw form, that's what it means. Okay, so yes, he can actually file and be in these courts, and these are things that Alex Spiro knows. So again, I'm not sure why Alex Spiro would be willing to use such crazy tactics to quote unquote fight on behalf of his defendant when he can just do this the right way, right? It really makes me look at him very side-eyed with how he's handling this matter, because it does not necessarily have to be this way. And that's unfortunate for Jay-Z, but moving right along, we're going to go ahead and get into what is going on with TDJAKES and the Youngblood situation, because that is a very serious situation that's going on now too. The heat has been turned up by TDJAKES, and I'm going to get into those hot topics as well. Let's play a quick timer, and then we're going to get right into those hot topics, guys. So it looks like TD Jakes is absolutely not playing at all with this situation. This has become a very, very serious situation that I think Dwayne Youngblood finally understands just how serious this situation has gotten because he has filed a response to the courts. But this response is not what we were expecting. I'm pretty sure it's not what the court was expecting. However, I do think that TD Jakes, his team, is probably rubbing their hands like Birdman right now with this response. Okay. So let's go ahead and share my screen regarding this and what is going on with this matter because, child, this is a hot mess as well. Now, we are into the case with Jakes versus Youngblood. With the Honorable William Stickman presiding. Okay, this case was filed on November 25th, 2024, and we have gone over the complaints already. And if you have not seen, you can go ahead and take a look. This complaint is everywhere, all over YouTube. There's a lot of YouTubers talking about this. But ultimately speaking, I did go over this the other day. I also went over the exhibits that have been filed here and how Larry Reed has been named in this case as well. Okay. Now, here's the thing. The bottom line is TD Jakes and his team are not playing around at all. They want this matter expedited. They want this situation resolved. And you can see here, even in this case where there was a motion to appear pro Hack Vice. So this was done by one of the attorneys in this case as well. And that order was granted. Okay. So this is something that happens often. There's a couple of other attorneys that also requested pro Hack Vice. And so again, this is something that is requested often in cases, where, parties don't live right necessarily within that state and so forth and so on. I know one of the attorneys practices out of DC and wanted to make sure that they could practice here in Pennsylvania, even though they had some other cases that they have practiced in Pennsylvania. Okay. If you want to look into all of that, you're welcome to get into that stuff. But the important parts of this case is basically what we were talking about the other day, how TD Jakes felt like he has been wronged, how he feels that Youngblood, along with Larry Reed and John Doe's 1 through 10, have been conspiring to commit libel against TD Jakes in order to collect funds, okay, to collect money. They asked him for $6 million, and Blackburn, which is an attorney who is often found in frivolous cases, has was the first one to initiate sending this demand letter to TD Jakes, who of course did not respond to him, but his lawyers then turned around and responded to Tony or to Blackburn, requesting if he wanted to, if he's going to take and accept, service on behalf of Youngblood. Whereas this guy was telling him to kick rocks or pound sand or whatever, he didn't want anything to do with it. Okay. And he's nowhere to be found now. Okay. Now, there was questions in regards to whether Youngblood was going to get another attorney, whether Larry Reed was going to use his attorneys on behalf of Youngblood, and so forth and so on, which I think would be only the right thing to do, considering that Larry Reed is the one that had him on his show. But I absolutely think that Youngblood should have been thinking about all of these things before he decided to get on Larry Reed's show to begin with, which obviously him being convicted child molester twice, right? And at least a third time has been as also been accused. I'm not sure how intelligent he would be enough to think ahead of the game, right? I think that he's obviously got some issues that he needs to work on. But bottom line is, let's go ahead and look at what this guy's response was to this case, because he did in fact file a response, guys. Okay. And we're going to look at this response now because this was nuts. Okay. And I don't know who is helping this guy with this case. Okay. But it obviously is not an attorney. And if it is an attorney, they're not a very good one. Okay. Now, we're going to go ahead and look into this. We got Dwayne Youngblood here and his response on December 20th in regards to Thomas Dexter Jakes versus Dwayne Youngblood. And here is the case number. Dear Judge Stickman the fourth, I am writing as a pro se defendant in the above captioned matter to respectfully request a 30-day extension to respond to the complaint and to file an anti-slap motion. Okay, now let's look up anti-slap. And I know a lot of people have been talking about that, but I definitely wanted to look up what that means because it's important to know what these things are. So, anti SLAPP stands for Strategic Law Against Public Participation. Anti SLAPP laws are designed to protect freedom of speech by allowing defendants to quickly dismiss frivolous claims that threaten First Amendment rights. Now, I've talked about this in previous videos before where we've talked about the differences between defamation and opinion. Okay. So I'm going to look up a little bit of that real quick. Defamation versus opinion, okay, and what the differences are, where you're, committing defamation against somebody and you're just giving an opinion, right? Because there's a huge difference in that. And we don't want to be wrong on this. So the main difference between defamation and opinion is that defamation is a false statement of fact, right? Where you're saying that a particular statement is an actual fact, while an opinion is protected speech, okay? So a defamatory statement is a false statement presented as fact that harms the reputation of a person or entity. For example, calling someone a criminal or a thief on social media is defamation. Okay. Now, an opinion is a protected form of speech, okay, which is what the anti slap motion would cover if this was an opinion that was given. Okay. An opinion is a protected form of speech, and people have the right to express their opinion about others. For example, Columbus Day should not be a holiday in the United States anymore is an opinion, right? It's not a fact that harms anybody's reputation. It's not a statement that's presented as fact, that would harm someone's reputation or their entity or something along those lines, okay? This is just a simple opinion from someone. And therefore, if the United States decided to file a lawsuit against such a person that said this, the anti slap motion would come into play because this person is allowed to say that, Columbus Day shouldn't be a holiday in the United States. If that's their opinion of it, they're allowed to say that. That's not hurting anybody's reputation. That's not causing any harm to anyone's entity. Okay. So, the defense of opinion protects people from being held liable for defamation when they make statements that are opinions rather than false statements that are facts. Okay. This defense is based on the First Amendment right to freedom of speech. Okay. So, yes, if you say something about someone and you say that this, for a fact that this person has done this or they have specifically done this or have done that, it better be an actual fact that you can prove, because if not, then they can get you for defamation. Okay. Now, if it's something that you can prove, then that's completely different. However, this is where it gets gray with this Dwayne Youngblood, okay? Because what he claimed on Larry Reed's show is that what he was saying about TD Jakes trying to kiss him, which again, I don't see where the crimes were, but trying to kiss him and hug him and all these other things, right? The things that he claimed as actual facts, right? And that what he said to him, that he wanted to be in this relationship, this sexual relationship with him, that he was going to take care of him the rest of his life, that he didn't want him sleeping with anyone else, and these kinds of things. He presented these as actual facts. Okay, so if they're facts that you can prove and that you're telling the court in this letter, which we're going to get into in a second, that you can prove, then the anti-slap motion wouldn't even work. Okay, because anti-slap would be where you're giving an opinion about something, where you're saying something like, "Oh, I think he's gay," or "I think he's, whatever." That's an opinion. That's not an actual, "Oh, this is what happened on this date and that time," right? That's an actual statement of fact, okay? So if you're giving a statement of fact like you did, I'm not sure how the anti-slap motion would even, how you could even use this in regards to this if you didn't just simply give an opinion about something, because that's not what you did, sir. Okay. So I think that if anybody was an attorney and they told you to use this, I think that they were terribly wrong in telling you this. Okay. but I don't know. I don't think you did. And we're going to get into why I don't think you used anybody's attorney. You said, I am currently in the process of attempting to retain local counsel. However, I am only employed part time. Securing legal representation has proven to be financially challenging. Well, sir, that completely goes against what Larry Reed was saying about you, and that you can afford an attorney, you can get help, you good in this situation and all this other stuff. But even with that, right? I'm wondering why, if Larry was so adamant about you being on his show, right? Has Larry even offered you to speak with his attorneys in regards to this matter? Has Larry offered to pay these attorneys regarding this matter, because he's so sure of your evidence that you claim, right? What happened to Larry's money, right? Is he going to help you in this? Like, you didn't think about, none of y'all thought about any of this to begin with. This was just, oh, we're going to go in just head first and just ask for $6 million from this man, without thinking that his attorneys would fight back, right? And that maybe you should secure legal representation prior to this, that maybe you should speak to an attorney, show them this evidence, right? Because again, if Larry was so sure about this evidence that you claim, I'm not sure why he would not introduce you to his attorneys, that you can present this same evidence to these attorneys who can vet this evidence and then provide legal counsel to you on how to proceed forward. Because that's what an attorney is for, right? That's what an attorney would do. No, instead, you just jumped headfirst into this and asked for $6 million from some other attorney who's known as an ambulance chaser, right? And now that the heat is on and TD Jakes done turned the heat up to hell, okay? Now he's nowhere to be found. And look at God. You can't find any attorney that wants to represent you on this matter, right? You find it financially challenging to do so, because no attorney is going to take $200 or $300 just to deal with this, sir. No, they're going to need thousands of dollars, right? Thousands of dollars and hundreds of dollars per hour to deal with such a case, okay? They're going to have to jump in like Alex Spiro is doing, okay, in this situation, and throw all kinds of stuff out here and hoping something sticks. They need money for that, okay? They're not about to come, with no money on this. But it's funny because Larry claims to have such money. How come he's not helping you in this situation? Is what I don't understand. I don't get it, right? Unless it's frivolous, as you both obviously know, right? Allegedly. Now, you said, I believe an extension would provide me with the necessary time to obtain appropriate representation and to prepare a thorough response and anti-slap motion to dismiss. So, first of all, right there, sir, the anti-slap motion doesn't make sense if you're saying that what you're saying is a fact, okay? What you have said about this man is a statement of fact. It does not go into anti-slap, because anti-slap is opinions only. Okay, period. So you didn't give an opinion. You gave a statement of fact. Okay, so that doesn't even matter. But another thing that doesn't make sense is, if you can't today afford an attorney and can't afford to retain legal counsel because you're employed part-time, and so it's been financially challenging for you in the past few days to obtain counsel. What difference would 30 days make? I'm not understanding how within 30 days you're gonna find enough money to obtain counsel. If nobody is willing to hand you that money today, you're not going to have that money in 30 days, sir. Okay. And I know daggone well ain't nobody going to send no GoFundMe money to you, right? Not no convicted child molester, no twice convicted child molester, right? What is going on with you? No, sir. Just admit that you had no idea what you were doing when you got into this. That's literally what happened, okay? And now you are facing a monster of an attorney team that is going to take you all the way out if you don't start opening your mouth and talking. That's your best bet right now, is to just spill all the beans, okay? Because right now you don't have a case when it comes to anti-slap. You don't have a case with that, okay? And you don't have a case without some attorneys here. Like you just don't, okay? It's just not going to happen. Your Honor, I have unwavering confidence that the court will discern the lack of merit in the plaintiff's claims, which I firmly believe constitute a violation of my First Amendment rights. What? The United States Constitution guarantees that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. Which you're right. You're absolutely right about that. But freedom of speech does not apply when you provide statements to the public as fact. And you went on a platform in front of 100,000 plus people and told statements of facts about TD Jakes that TD Jakes is saying are not true. And now you have to prove are true. And if you don't have the proof that these things are true, you in hot water, sir. Like, I'm just letting you know, because it doesn't matter what you want it to be. You can't make the law into what you want it to be. You can't make the law apply to what you want the rules to be. That's not how this works, okay? You literally have to apply the law to what actually happens within the parameters of the law. So if you were speaking an opinion about TD Jakes, that would have been a completely different thing. You are entitled to an opinion. You are entitled to feel however you feel. What you're not entitled to do is make statements of what you claim to be fact, knowing that these statements are not fact, knowing that this can damage and harm their reputation. You do not, and no law will protect you from doing such a thing. I'm sorry. You're wrong. And this is why you needed to have counsel before you wrote this letter, okay? Because unfortunately, you don't know what you're talking about. And it's obvious that you don't know what you're talking about. And it don't even take an attorney to know this stuff. So, no, this is not protected under protected speech, sir. It just is not. Okay? So, the fundamental right underpins my ability to share my life experiences, truthful and supported by evidence, as protected speech. No, if it's supported by evidence and if it's truthful, then you don't need the anti slap motion. Okay, because the anti, again, slap motion only applies to opinion given statements. Okay, it does not apply to statements given as fact. That's it. Now, in support of my defense, I intend to present 7 sworn and notarized affidavits which corroborate the facts I have shared for over 3 decades regarding the trauma I endured as a teenager as a result of the plaintiff's and others' actions. So let's break down that very loaded statement that you just said, okay? Because what you said is that you intend to present 7 sworn and notarized affidavits, okay, from which corroborate the facts, quote unquote, that you have shared for over 3 decades. So again, you're claiming that these are facts, okay, which now would go into slander if it's not actual facts, because the slander would mean that you wrote this, okay? Or libel. I'll look it up in a second. With slander and libel, one of them is where you say it, and the other one is where you write it. Okay, so this would go into libel if it turns out that you wrote some affidavit, or you told somebody a story, right? And they are signing an affidavit saying, yes, he told me this story 15 years ago, or yes, he told me this story 20 years ago, or whatever, right? If it's 7 people that are saying, oh, yeah, he told me about this, but that's all they don't have actual evidence of it. They don't have pictures. They don't have, video. They don't have any of this stuff, right? They don't have no grainy pictures or nothing. They don't have no voicemails or anything like that. I'm not sure what you think a sworn affidavit of you telling somebody a story and how that's evidence of them. That's not evidence, sir. Okay, that's just literally somebody saying, yeah, he told me about it, but that's it. I can't say, it's true. He told me about it though, right? That's all it is. So again, that doesn't make sense. And then secondly, again, if these are facts, sir, Anti-slap does not apply to this. Okay. Now, he said that he's going to provide these 7 affidavits that were shared over 3 decades regarding the quote unquote trauma he endured as a 19-year-old, right? As a teenager, quote unquote. I mean, he's still a teenager, but a 19-year-old as a result of plaintiffs and others' actions. Even though he didn't mention any others, he only talked about TDJAKES, right? He didn't talk about anybody else that did this. He was talking about TDJAKES that did this, okay? These affidavits will be accompanied by photographic evidence from the period in question, including images taken during the month I met Mr. Jakes and during events at the church where he preached. Child, we about to look at these pictures in just a minute, okay? Additionally, I will provide documentation of complaints I made to the senior bishop of Higher Ground, Always Abounding Assemblies, or Haga, whatever that is, right? Of which Mr. Jakes is vice bishop. These complaints include a conversation facilitated by Senior Bishop Sherman Watkins between myself and Mr. Jakes during a visit to my church between 1992 and 1993. At that meeting, I directly confronted Mr. Jakes regarding his actions, and he made a revealing admission that supports my claims. What is the admission? Because you haven't told us what that is. Like you just, that was a very vague response to that, right? That you had a meeting with Senior Bishop Sherman Watkins and Mr. Jakes, but then you said at that meeting you confronted Mr. Jakes and he made a revealing admission that supports your claims. But what was the admission? What did he say, right? And where's the evidence of this conversation? It is important to emphasize that I have expressed concern about these events spanning multiple decades in the 80s, 90s, and early 2000s. Despite my consistent and public recounting of these incidents, Mr. Jakes did not see fit to file a defamation lawsuit against me during any of those years. Well, it's possible that he didn't know that you were talking about this to these people, right? It's possible that he wasn't aware of it. So, what reason would he need to file any defamation lawsuit if his actual person was never harmed, if his reputation wasn't harmed, if he wasn't aware of it? I'm not sure why he would have done that then, if that was the case. He said, despite my consistent and public recounting of these incidents, where's the public recounting of this? Mr. Jakes did not see fit to file a defamation lawsuit against me during any of those years. Where again is the public recounting of you telling people that TD Jakes had groomed you over these years? Where is that? Because I don't know where you're talking about. We need to see evidence of these things, not you just saying it, right? You gotta show us. Got to show and tell here. This is the real deal. Okay, this ain't Larry Reed Live. This is the real deal. Okay. Mr. Jakes did not see fit, as you said, right? Then you said, this inaction suggests that Mr. Jakes himself recognized the validity of my statements or deemed that unworthy of legal challenge at this time. Or it suggests he didn't know that you was telling anybody anything like this, right? Or it suggests this never happened and now you're coming out saying this crap and now he's suing you. That's what it suggests to me, right? Furthermore, it is telling that Mr. Jakes actively participated in my 2004 ordination as a bishop at Haga, right? Serving as one of the consecrators despite his full awareness of my public statements about his actions. Well, that speaks more about you than anything, right? I'm not sure how this, would speak to him if you're claiming these actions and nobody was telling him that this was happening or anything along those lines or anything concerning any of this. I'm not sure why you didn't speak up about that at the time. Why he should be speaking up, but you should be speaking up. You're the victim, right? You said these facts highlight the baseless nature of the current lawsuit and further affirm my assertion of truth. No, it really does not, sir. I'm sorry. It doesn't. Okay. You said the legal principle at stake in this case is grounded in the precedent established by New York Times uh, versus Sullivan, and he used this. I guess this was a case law which provides robust protection for individuals expressing opinions or recounting personal experiences, even if they are controversial, providing they are truthful or expressed without actual malice. Exactly, sir. Exactly, sir, which is unfortunate now. You have to prove is truthful and without malice, okay? Furthermore, in Hustler magazine, okay, he wanted to use Hustler and a case law for that. The U.S. Supreme Court reaffirmed that speech about public figures related to matters of public concern enjoys heightened protection under the First Amendment. The United States Supreme Court decisions emphasize the paramount importance of safeguarding freedom of expression, particularly in cases involving significant public interest or personal narratives. I respectfully request the opportunity to include photographic evidence with my forthcoming filings to support my assertions. Now I was like, okay, well maybe he about to show us some pictures of him and TD kissing or him and TD Jakes together. It's about to get real, right? And then it says this includes a photograph of myself as a teenager taken during the month I met Mr. Jakes. And I'm looking in this picture and I'm like, let me make this picture bigger, right? I don't see TD Jakes anywhere in this picture, right? Like I just see some kid who can't dress in this picture. That's what I see, right? Okay. All right, all right. Let's go on, right? And then he says, a photograph of myself performing at the church where Mr. Jakes was preaching during the relevant time. Not was preaching that day, not was on the stage with him, not hugging him or kissing him or anything. Just it's a bunch of people singing in the choir at a church that TD Jakes allegedly had preached at some point in time. And this is him singing at the church when he still couldn't dress as a 19-year-old. Okay. So, okay. Nowhere in that picture do I see any of the Jakes family. I don't see TD Jakes anywhere. I mean, what is going on here, right? Like, what is happening here? I see a dirty carpet. I see a kid that can't dress, and I see pictures from way back in the day. That's what I see. Okay, so okay, I mean, let's move on. And then he says, photographs documenting my 2004 ordination ceremony with Mr. Jakes officiating. And we finally see a picture of TD Jakes, right? And I'm like, oh boy, here we go. We got a picture, right? But where is DUANE Youngblood in this picture? You know? I mean, this picture could have been from anywhere at any time, as if Bishop Jakes hasn't worn these kinds of outfits, many times at many different, officiatings and different situations. So this doesn't prove anything. This is just a picture of him officiating somewhere, and we don't know if this is his ordination or not because we don't even see him in the picture. Why wouldn't he include himself in that same picture? Where Bishop Jakes is kissing him or something that would substantiate what he has said. Then he says, I contend that this lawsuit represents an attempt to silence me and suppress my First Amendment rights. No, no, this does not cover First Amendment rights when you're saying something is a fact that you have to prove is an actual fact, okay? Not an opinion, but proof of it being a fact. You said, it is neither unlawful nor defamatory or truthfully share or truth to truthfully share one's life experiences as I did during my interviews on October 28th and November 3rd, 2024. Plaintiff Jakes has used his position to harass, and this is where it gets really bad, guys. Plaintiff Jakes has used his position to harass and target me throughout the years. And as recently as November 3rd, 2024, has had his son, Jermaine Jakes, reach out to me and threaten me on social media. This quote unquote threat is what led me to seek out legal counsel. But wait a minute, you just said you ain't got no legal counsel. So which one is it, sir? Do you have legal counsel or do you not have legal counsel? Like I am so confused right now on this legal counsel situation, right? Is that when you went over to Blackbird? Is that when you got to him? Child, listen. You said, this threat led me to seek out legal counsel who has now since abandoned you, right? As I was and am in fear of my life and safety. What? Upon information and belief, Bishop Jakes and his family have a reputation of having individuals who challenge them or expose their dirty dealings disappeared throughout the years. That is a major, major allegation, sir. Okay. And it's bad enough that you're already facing allegations of libel, right? Where you would now commit libel within your within your response to the court. Like, this is crazy. This is crazy. Okay, you do know you have to prove these things every single time you say something that is slanderous or considered defamation. When you're stating it as a fact, right, as a statement of fact, you're saying that this family is known to have people disappear throughout the years, right? If they go against, if they go against them, if they challenge them or expose their dirty dealings, right? That is a statement of fact that you're making that has to be backed up with actual evidence. So, once again, within your own statement, within your own response, you are committing yet another action of libel if it turns out that what you're saying you can't prove. I don't know what attorney you were talking to, but they did not help you at all. And then you proceeded to show a screenshot of Jermaine D. Jakes, right? Which again, we don't know if that's really TD Jakes' son or not. We don't know who this could be, right? This could have been anybody making this page up, acting like they're them, and then you taking a screenshot of them, right? And saying, hey, this is TD Jakes' son, right? And this is what he said. And then as of November 3rd, he goes up and gives you three question marks and said, you might be in dangerous territory, DUANE. Just be careful. That sounds to me that if somebody does say that, right? Yeah, it could be taken as a quote unquote threat, but it's more or less taken as, yo, you're out here committing slander and defamation. You're over here jumping up on this man's panel twice now in a week, telling a story about a man, and you obviously can't back that story up. All while you're asking for $6 million, right? That is dangerous territory that obviously you can't afford, which is clear you can't afford to do. So you might want to be very careful in what you're doing. I think that was very good advice that he would give you, okay? Because it doesn't make sense that a person of your stature, your financial stature, would be coming against a man of TD Jakes' financial stature, knowing that you're not telling the truth, knowing that you don't have any evidence of the things you're saying, and knowing that this is frivolous and this is nonsense, right? And if you're doing that, that is very dangerous waters for a person of your financial stature to be going into, considering you can't even afford an attorney to even look over your answer to this case. It's obvious an attorney has not helped you with this. Now, you said, in conclusion, I respectfully request that the court grant me a 30-day extension to secure legal representation and prepare and file my anti-slap motion to dismiss, which you're not going to get because I'm confident you won't get that. Now, I'm saying I'm not the judge. It's always up to the judge to decide, but I'm pretty confident you will not get an anti-slap motion to dismiss, considering this was not an opinion you gave. This was a statement of fact that you gave, which does not apply to anti-slap motion. Okay. And then you said you need 30 more days to extend to secure legal representation, even though you've already been granted a permission to extend, which you respectfully declined already. Okay. And then now you're asking for this after saying you can't afford an attorney. Okay, you don't have the money. Look, you work part-time and you don't have the money to get an attorney right now. You've been having a hard time with that. So, not sure why within 30 days all of a sudden you would have the money. Okay? So, why should the court provide this for you? Right? Because of this. No, I think your best bet is to get on the side of TD Jakes and let them know what has been going on here and who's behind what, who's who's the makers of what, who's John Doe 1 through 10, and that's your best bet right now. And perhaps TD Jakes will give you, a little bit more grace and mercy in this situation, because this is not a good look for Dwayne Youngblood at all. But either way, guys, it's unfortunate that this had to happen this way. Yeah, but I don't think that Dwayne Youngblood has a dog in this fight. I think he most definitely will get ran through the ringer with this situation if he continues to play around with TD Jakes like this. And I don't think that's a good look for him. So hopefully he will come to his senses. But either way, guys, y'all let me know what y'all think in the comment section, and I will talk to y'all later. And peace, guys. Thank y'all for sticking with the pre today in regards to these cases. And peace, guys.